Today's video is entitled The Custody Evaluation Blind Spot. First, before we go any further, some definitions so that you can understand the terms used in this video. Pendente lit. It's an adverb meaning during litigation, while the suit is in progress, while the case is pending. Next, discovery phase. That's that point in a lawsuit during which each party has the right and opportunity to identify and gather evidence from the opposing party to prepare the case for trial. All right. With rare exception in Utah, so rare that it might as well be non-existent, the way courts insist upon custody evaluations being conducted consists of, generally, 1. The court imposing one and only one child custody and parent time schedule during the pendente lite discovery phase of the case. Now that's a period of no less than 180 days, mind you. Never to be deviated from the entire time. That temporary order stays in place the whole time the custody evaluation is being done, and then the evaluator is ordered to first, compare the actually implemented so-called temporary child custody and parent time schedule against the other parent's proposed schedule without ever having the other parent's proposed schedule implemented too. If ever there were an example of an apples to oranges comparison, this is it. And then the custody evaluator is expected to make a recommendation as to what custody and parent time schedule is in the child's best interest, based on really no comparison at all. Why? Well, concisely stated, there's nothing in UCJA Rule 4903, that's the custody evaluation rule, that requires a custody evaluation consist of nothing but educated guesses. Otherwise stated, Rule 4903 does not require that one and only one temporary custody and parent time schedule be imposed upon parents and the children throughout the duration of the pendente lite discovery phase of a pending child custody dispute. Indeed, it is hard to imagine, 1, a worse, less probative way to conduct a custody evaluation than to require one and only one temporary custody and parent time schedule be imposed throughout the duration of a custody evaluation. And 2, it's hard to imagine a better, more probative way to conduct a custody evaluation than to implement and compare and analyze the parents' respective competing child custody and parent time schedule proposals as to what the ultimate custody and parent time schedule that best serves the best interest of the child will be. Implementing during the pendente lite discovery phase of the case could, in many, likely most cases, eliminate any need for a custody evaluation altogether. But even in cases where a custody evaluation is deemed necessary, the custody evaluator, the parents and child, and the court would only benefit from comparing and analyzing the parents' respective child custody and parent time schedule proposals in real time for the purpose of obtaining actual, verifiable proof as to what ultimate custody and parent time schedule best serves the best interest of the child. Implementing, testing, comparing, and analyzing the parents' respective competing custody and parent time plans during the pendente lite and/or discovery phase of the case would not take any more time than already permitted under the rules of discovery and procedure. But what it would do is spare the parties the cost of the custody evaluator potentially. And if no one else has the courage to assert it, I do. Rarely does a conventional custody evaluation and the quality and reliability of the recommendations stemming from it justify the time and money expended on such a custody evaluation.